Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. We have a major development to report to you today in the matter styled as Steve Goncalves, Karen Laramie, Jeffrey Kernodle, Stacy Chapin versus Washington State University. The defendant, Washington State University, has now removed the state case to federal court. Repeat, a notice of removal was filed in the state proceeding initiated in Saget County earlier this month, January 2026. The notice of removal to federal court has now initiated an action in the United States District Court, Western District of Washington at Seattle. What this means is that the state proceedings are now concluded and will not be reignited again until or unless there is a remand, a filing by the plaintiffs, or sometimes this will happen by the district court finding it doesn't have federal jurisdiction to entertain the action. Sua sponte, sometimes district court judges will do that because federal courts have limited jurisdiction. State courts have general jurisdiction. Let's see what the defendant, Washington State University, is saying. There's a case number if you'd like to see the federal proceedings. Case number 226CV00301. The defendant has stated that this case alleges a violation of a federal statute, Title IX of the Education Amendments of 1972, 20 USC Section 1681. We, in fact, on our sister YouTube channel went over this claim earlier this month in a presentation. Defense is saying that the defendant, WSU, is an entity of the state of Washington and that plaintiff's complaint has not yet been answered by defendant WSU. On January 7th, a complaint was filed in the Superior Court of Washington for Skagit County entitled Stephen Goncalves et al. Versus WSU. The complaint was served upon the defendant WSU on January 7th, 2026. This notice of removal is being filed within 30 days of the filing of the complaint, alleging an action under 20 USC Section 1681 against defendant WSU. That is the grounds for removal, because there was a federal claim in there, ladies and gentlemen. The defendants are alleging grounds to have this case entertained as the proper venue for this action. Paragraph 7, Section 1 indicates that the Western District, that's federal court, is an appropriate venue for removal as the judicial district that embraces the place in which the action is pending, and that venue in Seattle versus somewhere else, ladies and gentlemen, is also appropriate in the Eastern District of Washington, and defendant reserves the right to file a motion to change the venue thereto. Defendant WSU is reserving all rights and defenses, and this notice is made without waiving any defenses that WSU may have in response to this lawsuit. This is signed the 27th day of January 2026 by Nicholas W. Brown, Attorney General for the state of Washington, by and through the Assistant Attorneys General Jordan Jones and Connor Callahan. If we could add some commentary here. If the defense challenges this removal, they will have a specific time frame to do it in. And so we will continue to monitor the federal docket, which is where this lawsuit is now resting, for any challenges to removal any motions for remand, anything that the federal judge sua sponte does. And then further on, we will notify you when a responsive motion, which would be something like a motion to dismiss, or a responsive pleading is filed to the now federal action known as Goncalves et al. Versus Washington State University. Until next time, this is Kathy. Thank you for joining us here today.